And recording in progress. Okay, hi folks, and welcome to the penultimate Zoom for Laws 11062 Contract Law B 42 2018. Tonight we will be looking at international issues, and I was just having a chat with the lovely lady Tam here. We won't be spending a whole lot of time on international issues this evening because, well, there's a couple of reasons. It's a reasonably minor focus of our curriculum for Contract Law B. And it's quite interesting for those that have the 2013 text that has that chapter 28 in it, that the international contracts chapter in it. They've actually snipped out that whole chapter for 2018, which is quite interesting. And in fact, in the 2013 text, at the end of every single chapter, you had another whole section at the end dealing with mostly American and other jurisdictional issues for the same kind of subject matter as each chapter. So as you went through on the chapter on mistake, misrep, and all of the other chapters of the text, there would be a little international perspective section at the end of every chapter. I never got my students to read those sections when they were in the text, so I was fairly relieved when they all got hived out of the text. And you're probably wondering why, given that, you know, there's such a strong focus on internationalisation of the curriculum and all of that kind of stuff. Now, yes, there is that emphasis in the curriculum, and I think rightly so, obviously. However, in Contract B, I am a realist, and I appreciate that you guys are on a really super steep learning curve this term. I mean, I think if you probably look back to how you thought about legal analysis and how you ripped apart a problem, how you structured your answer, it probably to you for Contract A looks fairly simple. Now that you're at the end of Contract B and you've had like another whole term of building on the stuff that you started to do, very steep learning curve. And I think if you look back, you'll just see there's been a steady progression of increasing the torture level from Contract A to Contract B, as there should be through any progression from an A subject to a B subject, so in towards B as well. But particularly for Contract B, it definitely does ramp up the demand for a certain level of critical analysis and being able to rip something apart, turn it around in your head many, many different ways, and come at it from different perspectives so that you can get the best possible answer down in terms of you know, what your client expects at the end of the day. It is a very steep learning curve, and I personally think that to inflict on you, in addition to all of that, a demand that you not only are up to speed with Australian law in this area, but also, for example, the main cross-jurisdictional comparisons, you know, the UK law and US law. I think that would be really too much of an ask at this point. And it's really enough of a task for you guys to get your heads, your collective heads around, for example, mistake just in the Australian jurisdiction, let alone trying to work out what the US is like or the UK. Now, interestingly, for those that do have the 2013 text, as I said, a lot of those little sections at the end of the chapter would discuss American law. And I think they've obviously seen the error of their ways, but particularly for the US, you know, US law is, wow, you thought Australian law was complicated, and then you look at the US, and you've only got to look at the US in terms of what we're looking at this week, particularly the application of things like our consumer guarantees is amazingly simple compared to the spider's web of legislation that you get over in the US, and the different government bodies that deal with different things. There is multiple pieces of legislation, and I don't know if you went and did the suggested tutorial today, which was to just try and find, go and have a look at your last, purchase that you did, excuse me, from an online seller, and try and find their terms and conditions, and then try and find the governing consumer regime for that contractual relationship that you entered. I guess historically most students have picked, a transaction that did involve the US, because there's just so much that gets sent over from the US. It's usually US or China. And trying to find the appropriate consumer protection legislation over there is an absolute nightmare. There is a uniform consumer protection-ish piece of legislation. However, that is only adopted at state level and only by a handful of states. So there's no real level of consistency over there. And even, I will share this because I think it's kind of cute. But if you, I'll just share my desktop, my messy desktop as per usual. Now, where is it here? So because there's no one piece of legislation, there's no listing of the relevant pieces of legislation here. The FTC, the Federal Trade Commission, is the bureau that you would run to if something nasty happened in terms of a consumer transaction over there in the US. But you try and find information on, the legislation or where your protections springs from. And it's like trying to find a needle in a haystack. This is the landing page that you go to. And unless you want to do something real... Oh, hi, Michael. Hello. Wow. 2 takers tonight. Nice. We're just shooting the breeze in relation to, international issues. And I was just saying, look, I take a fairly light touch approach with this because I consider, it's hard enough work for you guys to get up to speed with Australian law so far as Contract B is concerned, let alone try and get your heads around multiple jurisdictions. There are some interesting things in relation to international law that I wouldn't mind just touching base with you on. But the task for this evening was to find the consumer legislation. Here we go. Identify a recent purchase that you've made from a retailer, not through eBay. I'll come back to that in a minute. Go to their website, look at the T's and C's, see whether they have a choice of law provision. If it's not an Australian jurisdiction, and let's face it, it probably won't be if you bought something online. How easy is it to find what consumer laws apply? And I was just saying to Tam, invariably the purchase will be like China or the US, neither of which is a jurisdiction you really want to find yourself in terms of consumer protection. But then we just went to the Federal Trade Commission in the US, And I was just saying, it's really hard this is the landing page, and unless you're really ticked off and you want to just file a complaint straight away, in which case you just click there. If you actually are interested in finding out about your rights as a consumer, it's not really an easy thing to do. You got this typical, tips and advice, but that's like, what are free resources? So if you want to go ahead and order some stuff, you can. But look, unless it's identity theft or telemarketing, there's not a whole lot of resources here. I mean, there's just alerts on stuff that's happened. So, okay, you think, all right, well, there's nothing there. So maybe we'll go to the resources page, which you would think logically would set out your rights as a consumer. Consumer protection basics, that seems to answer the search question, but then really it comes up with this, which is, what about if I've bought something and I want to return it? Where's the information? Here, in terms of managing your money, it's all, financial related stuff and just tips. Okay, so it's not there. Using credit and loans, again, basically financial issues there.
So, sorry, AJ, do they not have like a consumer guarantee like our ACR? So it's nothing like that, not even remotely like ours. So in other words, consumer beware.
Land of the free, home of the brave. Yeah, no, apart from that, and I thought the same thing as you, Tam. Like I did post up a little article by Justin Malbon, which was a 2013 article. It shows you just how fast this space is moving. And he does go through some of the US stuff. But I thought, surely, this was written in 2013. Maybe something's, maybe they've picked up their act a bit or something. Anyway, I got sick and tired of poking around in this wretched website because there's really nothing much that I can see that's intuitively of any help. And then you look at, in desperation, I went to Wikipedia. And this is why it's still all the same as it was when the Malbon article was written. So there's just this plethora of laws that are split, amongst all of the various different issues that you would come across as a consumer. And it's still the case that there is just these few handful of states that have adopted that Uniform Deceptive Trade Practices Act.
Delaware is like 80% of American companies' headquarters because the laws there are easier for companies, I believe, and setups and taxes.
Delaware is the jurisdiction that many overseas corporations choose to incorporate their American limb. There are many different jurisdictions that offer different benefits, and it just depends on what benefits you want as to where you would incorporate, was my understanding. I know that there are a lot of corporate registrations in Delaware, and certainly any clients that I've had that wanted to register an American company, we've always just defaulted to Delaware. I think it has the best, company-friendly regime. But there are, as you can imagine, there are a million little small to medium-sized enterprises in the US that haven't really consciously thought about where they should register. Illinois, Maine, Nebraska.
It seems so backwards for a first world country.
Well, if you think about it, it's very consistent with, the American ethos of, it's all about the trader, trade, encourage trade. And I think there's far less, I think there is a consequent, perhaps what we would call over-focus on the trader's rights as opposed to the consumer's rights. And I think that's just, it's part of the, I don't wish to be, I don't wish to be too general about it, but that's what the US is famous for, isn't it, really? Trade and expanding trade. And mostly the laws that come down in this area tend to be, reflect that ethos. So it's much more a caveat emptor kind of a jurisdiction than, either the UK or Australia or the EU for that matter. So it's quite interesting because I was going to say to you, the other reason why I don't particularly like this focus in chapter 28, and hence why I kind of cut the guts out of it for you, is because in actual practice, this stuff almost never comes up. I think I had to refer to the Incoterms like once. That was right back in my articles of clerkship in like 1996. There's very few, unless you're advising clients that are in those really, those kinds of trade which are very big ticket, so big dollar value, and it's the kind of trade that has a very long history. For example, shipping, you just don't tend to find you need to go fossicking about in the conventions and the treaties and UNIDROIT and, even Incoterms. Incoterms is about the only one, as I said, that I've ever had to refer to. So I think if we, and this 2013 paper that I got you to read, shows, just as I said before, how fast this area really moves, because this is basically Justin's big pitch for trying to get some sense of consumer protection globally now that we're engaged in so much global trade. And he proposes developing this, standard form contract, a bit like the Incoterms that, everybody's agreed on, that are fair and balanced, and they're just available online. And he says, traders might choose to adopt them because, of the good reputation that they might get from consumers. Look, I think if it came down to it, any trader that was looking to implement a standard form contract for internet trading, where there is potentially, hundreds of thousands of transactions going on, I think they're probably going to want to draft their own contract rather than have some, honky kind of fair, balanced contract. I mean, it's just a quirk of human nature, isn't it? I mean, you'd feel more comfortable if you were launching trade on the internet, having had your own little lawyer prepare up for you a contract that suited you rather than adopting something that was online. So I think there's always that problem. But the other thing is, I think it kind of misses the point, and that is traders, in my point of view, will just act rationally. Like, if you've done any economics, you'll know we're all rational maximisers to some extent, and we'll choose what suits us best. Traders are no different. They'll go for their own contracts. I don't know that there is enough of an impetus to adopt anything across the board that would be beneficial. Why would you? But it also says to me, you're looking at things from the wrong perspective, because there's no incentive for traders to change. So where can you change that mix if there's some unfair terms washing out at the end of the day and impacting all consumers? How do you change that dynamic? And I think the answer is not some funny little standard form contract that you whack up on the internet and hope people use. I think you've got to take the bull by the horns. I don't think the country-specific legislation will only go so far. Our ACL does a pretty good job, and I'll talk about that in just a minute. But I think the way that things will go, if you want my humble opinion, is things like, if you look at PayPal, right? But the trader has no incentive to give you fair terms. Okay, they try and exclude whatever they can exclude. Where can you impose some fairness in that timeline of trading from go to why? I mean, you've got now people like PayPal, Afterpay, those kinds of third-party interveners, if you will, in the whole transaction. And they, by virtue of them being in between buyer and seller, are able to then inject what they see as standard terms, which come along with the use of their payment facilities. And I think this is probably stands more chance. And in fact, if you've ever had to claim on, and I'll talk about eBay in a second, but if you've ever had to claim on the PayPal Shop with Confidence thing, it's actually quite good. So you have a third-party credit intermediary that has a much greater incentive, I think, than the trader to make sure that that deal goes well. Because if that deal goes well, then it's repeated millions, hundreds of millions of times over daily. How many transactions would PayPal have in a day? They have every incentive to make sure that their transactions go smoothly and that the parties are happy. Trader like Amazon, what are they going to care if one trader complains to them? They're not going to care. And that's effectively what Justin says in his article. So I think there's probably more scope for, if you want to inject some sense of fairness into this dynamic, maybe you look at people like third-party credit intermediaries that have no real vested interest but do want things to go smoothly. Also, eBay, you will find. Now, eBay's interesting. Do the consumer protection provisions apply to eBay purchasing?
I didn't think they applied to auctions.
No, they don't. No. So if you've bought via auction, it's not going to apply. And how many transactions would occur like that of a day? So again, you've got this third-party intermediary. They're not really directly interested in the transactions that are going on their platform, but they do want the parties to walk away happy because their platform will be more successful the more successful transactions they have. So they have, when eBay first started, it was really interesting. It was far more like a traditional auction in terms of, you know, once the hammer's down, that's it. There's no change of mind. There's no, oh, I didn't know about X or Y, you know, unless there was some really grievous conduct that had gone on by the seller. There's no real way to back out of an eBay purchase. And now that's really basically flipped on its head. And they have quite good customer service pardon me, policies that are designed to ensure that, for the most part, buyers will walk away happy. So I think there are your obvious, I guess, points of leverage to me, to my way of thinking anyway, of trying to get some consumer fairness happening in amongst all of that argy-bargy of trade that's going on out there on the internet. So that was my take on Justin's thing. Nice thought about having a very fair set of standard terms up on the internet. I don't think it would really stand much of a chance of being adopted. I do think this kind of thing will work. There are other jurisdictions where, like the US, very little is done for the consumer. By contrast, our consumer protection provisions are well known internationally as being right up there amongst the best. And I did want to touch base with you about this delightful little case that I don't know whether you've heard about, but it had to do with Valve. I'm gathering that neither of you are online gamers. Valve is, it's an interesting, so this is Steam. Valve is the company that owns Steam. Valve is based in Washington State in the US. Wildly successful gaming platform. You can download all sorts of different games, as you can see. Very interesting dispute arose because, from my understanding, a number of their games were, I mean, this all looks very fancy, but apparently there were quite a number of consumers that were not terribly happy with some of the games that they downloaded from the Steam platform. And it's a subscriber service. So they have this subscriber agreement, and the terms and conditions, obviously, when people complained, the Valve chat box would tell them, go and have a look at the subscriber agreement. Sorry about this, but we've just excluded all consumer protection provisions basically anywhere. And so tough luck. Now, obviously these people were very, very annoyed about that because they complained to the ACCC. And if you have a look, I'll just go to the decision for you. This is the thing I love about Australia. You know, when someone ticks us off badly enough, we don't really care who we take on. And the ACCC took on, so I'll go up here, took on Valve in all its glory with its Americanness. And I love how they have capitals for everything, don't you? We're not shouting at you really, but, you know, we kind of are. So this is all the different representations that were made in their subscriber agreement. Now, this subscriber agreement, that if you're so minded to have a look now, is very different, and I'll show you how it's different. But in 2013, it had all of these different representations. So can't get a refund, tough luck, we don't care, things aren't of good quality, tough luck, no refund. Contractual exclusion of statutory guarantee, contractual modification of statutory guarantee, no refunds, no entitlement to refund or replacement, blah, blah, blah. There was a whole stack of, you know, naughtiness that went on.
So I can be a dodgy man, just sell dodgy stuff and go, well, I'm just going to exclude it all.
It's essentially
That's their thought process, obviously.
Yeah, and because
Wow.
now that we have in a most superficial and unsatisfactory manner discussed the US position with my wonderful example of Googling and Wikipedia, you can kind of understand how companies get away with it that are based in the US, because the US, they can. If they can get away with it and argue the point that this should be dealt with under American law, they're home and hosed. Home and hosed, by and large. And so...
Well, I guess if you can do it, why not? I guess that's the attitude, isn't it?
My point before, in order to make traders change their ways, you've got to give them either a carrot or a stick, don't you? And most times there's not enough of a dollar value in most consumer transactions to constitute a carrot, to actually make them be nice to the consumer, is there? What they're after is a million different consumers, and each of them would hold very, very little bargaining power compared to the actual company themselves, the trader themselves. So they had this wonderful set of, here we go. They had this wonderful set of provisions there that they thought was rather good. Now, I'm trying to get to, so they were alleged to have breached, obviously, the misleading and deceptive conduct provision. And they had come up with these terms, which I had shown you before. Now, part of the issue, if you have a little look, when you were looking at the consumer guarantees, did you look at the, the exclusion provisions and the that part of the Competition and Consumer Act at all? You didn't really?
I don't know. It's all becoming blur.
Too long ago. Okay, so if you have a little look, so you would have probably looked at 64, guarantees not to be excluded by contract. Yeah. So that's one nice little provision, obviously, that you need to be aware of. The other one in terms of international provisions is the conflict of laws section. And this is the one where, if you have a contract, if you've read the chapter, you will know that there are tests called the Bonython tests for working out what jurisdiction should apply to a contract. And you've got the subjective test that comes first, and it says, if the parties have said in the contract what jurisdiction they want, generally that will be enforced. Or if there's nothing that says that expressly in the contract, then the court's left to work out what jurisdiction is. When one party's overseas and one party's here, we have to work out where the heck we can enforce this thing. Then there's the Bonython test in the second limb that says, what's the most natural jurisdiction that seems to apply here? What's the closest and most natural? And so they look at a number of different indicia to try and work out where, whether the contract should be more closely aligned with the overseas party and therefore the overseas jurisdiction apply, or whether it's more closely associated with Australia and Australian law should apply. So this section here, 67, basically says if the proper law of a contract would be Australia, but a term says it's going to be somewhere else, or if a contract tries to substitute another country's law for ours, the provisions of this division apply. And they go through in the Valve case, they pick that apart. This was really the main, this only got handed down last December, so it's pretty recent. And it was I think the first time that 67 had really been picked apart by a federal appellate court, because when Justin wrote his article in 2013, Section 67 hadn't been tested yet. And so what Valve obviously was trying to do was say Section 67 means if they were trying to say our subscriber agreements say that Washington law is going to apply. So, you know, in that case, really, given that the law of Washington state applies, we fall outside your consumer guarantees, because Section 67 means that it's only where the contract law would be Australian contract law that those consumer guarantees apply. There is, I guess, some logic to that argument. The court came back with, as you would expect, given that this is a consumer protection provision, no, you can't unduly restrict the consumer guarantees to that purported meaning, because, you know, the consumer guarantees don't just apply to contracts. They apply to anything, you know, procurement, supply. There's a whole list of, you know, synonyms that are used. And if their interpretation had held, it would mean, quirkily enough, that you could carve out of our consumer guarantees, you know, your transaction, as long as you had a contract and that contract said, you know, the law was going to be elsewhere. But if you did a trade and there was no, you know, there was nothing in the contract dealing with where the law was or whatever, then you'd be caught. They said this a bit nonsensical. So they had a good look at 67. They had a good look at their terms and conditions. And I think part of what ticked off the court so badly is even after the first instance, the judgment of first instance, because Valve took the typical US kind of attitude to things, it still didn't change its website. And so this obnoxious stuff was still up there. And I think by the time it came to, you know, the appeal court, they saw that reluctance to change their website in the consumer's favour as something that then went into the mix when they were considering what kind of a fine they should impose. Not fine, but what kind of a pecuniary penalty. And so originally they had said everything's got to be payable in advance, non-refundable. There was another thing down here. Here we go. Lovely. Limitation of liability. Not liable for anything. In no event will they be liable for anything, any damages, anything, even in the event of fault, tort, including negligence, strict liability, breach of Valve's warranty, and even if Valve has been advised of the possibility of such damages. I think that's just lovely drafting. So they specifically purported, and I can't bother finding it for you, but they specifically purported to exclude all consumer protection provisions of basically any other law. So the court got fairly annoyed with that, and as you can see there, imposed a $3 million penalty, which I think was a pretty good victory for the ACCC, actually. They were fairly recalcitrant and they did try it on. In fact, you could tell that the judgment at first instance, he basically throws up his hands and he says, you know, normally in the process of getting a matter to trial, you know, when someone first files proceedings, there'll be a list of disputed issues as long as you are. But normally in that pre-trial process, you'll focus the number of disputed issues down so that when you actually wind up in front of the judge, there might only just be a relatively short number of issues that are actually contentious between the parties and that have to be argued in full before the judge, and that the judge has to make a ruling on it. Valve just took every opportunity to bring every single issue before the court, and you can just see him rolling his eyes. It's quite a good judgment, the judgment at first instance. It goes up all the way up to appeal. As I said, only came down last December, right before Christmas. Nice little Christmas present for the ACCC. $3 million. Boom! So now, if you go and have a look at the subscriber agreement, I think that this is just hilarious. Where are we? Now, I'll get to it by doing a little search, because our little humble jurisdiction rates a mention. Isn't that lovely? For Australian subscribers, this section does not exclude, restrict or modify the application of any guarantee, right or remedy, blah, 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 conferred by the Australian Consumer Law.
Because I don't want another $3 million fine.
Yeah, that's it. That is it. So the humble little Australian underdog of a grand sum total of about 3 very dissatisfied gamers in the ACCC. I just think it's a lovely story. Took on a very large gaming company in the US and knocked them over flat. But look at this. Also New Zealand. So we have a reasonably good, I think, international reputation for having a consumer watchdog that will actually do something. And I think the decision was a sensible one. One of the interesting parts of the decision, which it puts a little bit of a break on things going full speed ahead so far as the ACCC is concerned, is that one of the things that you need to show is that, I'll come back here to the Competition and Consumer Act, and if we go over to, I won't.
Sorry, just to digress for a second. So did S67 override the whatever that test is?
Section 67 will override it in terms of allowing the consumer guarantees to apply.
Okay. So even though they actually set a jurisdiction, so that was part of the first test, so it was subjective, so what the parties intended, that was quite clear that they said that it was US state jurisdiction, but because we have S67, we were able to introduce that and basically override the first test. Yes,
and if you're wondering, does that mean that Australian law just suddenly gets to be applied to US citizens? This is the one break, in fact, that I was just referring to, and you've segued us nicely into that, and that is that in order for it to apply and catch the other party, they have to either be an Australian company or an Australian, or carrying on business in Australia. And this is the only thing that I think that at present limits the Valve decision slightly, because rather unfortunately, I think everybody was hoping when the first instance decision came down, the judge put some weight on the fact that, here we go, no, they're just talking about what they're, let me get to, okay, Let me go down here. Yes, third issue is whether the primary judge erred in concluding that Valve was carrying on business. Now, he based that on these factors, that they were carrying on business here. So he noted that they were based in Washington State, hosted and fully supported by servers in Washington State. Sorry, I've come down to the wrong thing. Anyway, these were all the things going against it. Provides worldwide service, game subscriptions are processed in the US dollars, not registered in Australia as a company, no subsidiaries here. And I think people were hoping that they wouldn't attach any real importance to the fact that they had personal property here in the form of physical servers. They rented rack space and whatnot from this tech company. And the servers were worth some millions. And that was one of the factors that ended up washing out in the mix. I'm just going to try and work out here, see if I can find for you.
So essentially, because they were selling to Australian consumers, that is deemed as carrying on business in Australia because obviously there's a transaction.
That's what we're hoping for. That's what we're hoping for, but it's a little narrower than that as it stands. But I think this is just kind of like, because this was really the first that I know of big decision where this kind of stuff was discussed. I don't think they wanted to just jump straight in and say, you will be carrying on business if you sell to Australian customers, because that's a very low threshold then for our laws to have an extraterritorial reach. And so we've kind of got one foot out the door, and all we need to do is take the other foot out the door now, in my humble opinion. So he said these are the reasons why they're carrying on business here. Many customers in Australia, 2.2 million accounts. The content was put onto servers in Australia. I would have been happy if these two were in the mix, in the decision. Here, this is the one thing I think that keeps the gate half closed. They had significant personal property and servers located here. And so they said that then, see, you got here, retail value of 1.2 million. Okay. They were configured by someone that came here, updated in 2013, spent a lot of money in updating it. But the other things are really, I think are uncontroversial. They incurred tens of thousands of dollars per month expense for rack race space and power for the servers. They relied on relationships with third-party members, content providers in Australia, entered contracts with third-party providers like Highwinds that provided some content here.
But being a douche costs you a lot more.
Yes. Yes. This is the only thing I think, if they hadn't, I don't know whether it still would have come down on the same side of carrying business here if these kinds of things were not in the mix. If they've got personal property here, see, it's interesting because they don't even have real property here and they're not incorporated here. So this is the only tenuous kind of hook, I guess, that they could find to anchor them here. I think it's interesting, how would you go if, for example, they had no personal property here? If it was just all done from an American company that maybe had, a massive load of servers elsewhere, what would happen then? I don't know.
So essentially this particular part was crucial to the decision or crucial to the argument.
These 6 reasons were the reasons why it was held to carry on business in Australia. These 1, 2, 3, 4, 5, 6.
Okay.
Yeah. His Honour concluded that thou have carried on business in Australia for these reasons.
For these reasons.
Yeah. So I don't...
So the argument would have been a bit weaker then if, as you said, if all of this was actually either on US soil or offshore elsewhere.
Yeah, I think it would have. But, you know, the law moves incrementally. And I think perhaps, you know, now that this has happened and there's been that precedent set, it may be easier the next time if they didn't have that much personal property here.
So this is all, though, to support the argument of S67.
Of applying, well, S67 was its own argument, but in order for the guarantees to have that hook, that extraterritorial reach, then there needed to be some way that they could say that the subscriber agreements were somehow, attributable to a person that was carrying on business in Australia. So I wonder if they had no personal property, but it was, you know, someone just massive that had, you know, millions of transactions with Australians on a daily basis. It makes you wonder whether the dollar figure of Australian trade, whether that would just push you over in the court's view into the category of carrying on business here. You know, if they turned over X million dollars per day in business here, would that be enough to constitute carrying on?
Well, as you said, this has now set the precedent, so it opens the argument for more along that track, I guess.
Yeah, I think it does. You know, they've got one foot out the door. I think they were probably looking around for something that made them feel a little bit more safe. And I've, you know, it's a little unusual to look for things like personal property. Normally they'll look for real property. So you can see they're kind of dipping their toe into the water, and now this has come down in their favour. I think, you know, it may well embolden them for next time. But $3 million, you've got to be happy with that, really, so far as the ACCC is concerned, I think.
And their terms have changed, so win-win.
And their terms have changed, but they're still in capitals. Maybe they should have highlighted them for Australians.
In other words, Australia, you suck. I'm going to really make sure that you know that whatever you want, we're just going to go, yeah, whatever.
Yeah, with an emoji going,
yeah.
I thought I would conclude our I just tend to think this is a bit more interesting to talk about than Incoterms or, you know, the treaties or anything like that. Well,
it makes it more real, this. I mean, I read all that stuff about the Incoterms and the Bathiath and whatever his name is, the test and all that sort of stuff. But this actually, I don't know, makes it more clear.
Yeah, and I think it's a bit more relevant. Like I said, it shows you that Malbon article was only written in 2013, and already, you know, he says, oh, what a shame we haven't had anything on Section 67. Well, not only have we had something, it's been all the way up through the appeals process, which in itself is a miracle because it's only been 5 years. You know, Section 67 hadn't been tested. You hadn't really had the growth of all of these third-party intermediary kind of consumer protection measures like you have now with eBay and PayPal, and I'm assuming Afterpay is the same. You know, so there's been quite a few developments even just since 2013. So this is where I think international private law will be headed. You know, it doesn't really matter what is in your contract so far as Australia is concerned. I think we have one of the best consumer protection regimes in the world. And now we've been shown to have one of the best consumer watchdogs that will actually jump in there and get dirty and get a decent, you know, a decent pecuniary penalty from people that are making a lot of money from doing dodgy deals and supplying crappy software. So and I don't know whether their software's improved since then either, but there you go. I think it's an interesting little
Probably not, but for Australia, you know, we're still got crappy software, but you can claim.
Yeah, that's right. Now, since you two gems have turned up for this evening, I'll give you the little piece of gold right at the end of the Zoom, which probably no one else will watch.
Considering I watched last week's an hour ago and I was the second viewer.
People, it would behoove you to look carefully at, let me just try and find the page. Here we are. Please make sure that you review pages 995 to 999 of chapter 28 of the 2013 text. It is on the Incoterms. And I'm just suggesting that might make you happy sometime in November. And that's it. My gift to you.
So I didn't actually, I know that you had something on Moodle. I don't have the 2013, I've got the 2018, but I think, is that the PDF that you've got attached on Moodle that I can download the 2013?
Yes.
Okay, cool. Because I haven't done that yet. As you know, I was dancing.
Much more important and delightful thing. If you read those sections, that's what you will need to read, so far as the exam is concerned. And
So what chapter was that? International contracts, 28?
yes.
Yeah, okay.
Chapter 28, those paragraphs that I just mentioned on the Incoterms would be a good idea to read.
That's the book?
Yes.
Yes, okay, just making sure which, yeah.
Yeah.
I've got one question. A few weeks ago, you gave us look up the Progressive Mailing House.
And Tabali.
Sorry?
Progressive Mailing House in Tabali.
Yes, and Tabali. Then you gave us the Lorinda and Lease, and then Lorinda and Kapala. Then you also said Shell versus Building Licensing Board. Is that right? I just can't find that one.
Chevel and the Builders Licensing Board.
Oh, Chevel. Okay. Can you spell that for us, please, on here?
SHEVILL.
Yes.
S-H-E.
V for Victor.
Yep.
I-double-L for Larry.
Okay. Not Shell. That's why I couldn't find it. I looked everywhere.
No, it's Chevel.
Chevel.
And it is cited in the 2013. It gives you the full citation in the 2013 text, and I'm sure it'll give it to you in the 2018. It's mentioned there as well.
I haven't looked, but I mean, as you said, I'm going to go onto the online databases anyway because I think it's in our favour to look at the full case.
Yes.
Yeah.
Yes. And once you have done so, it will be patently obvious to you why I've put those terms in the contracts. And from there, you should be able to join the dots as to the kinds of things that may happen between the parties. And if I were you, I would be fleshing out some hypothetical answer frameworks so that you can cut down your time in the exam. So, yeah, I would be marching into the exam with that set of contract terms that I've released for you, plus your little potted summaries of Progressive Mailing House and Lorinda and Chevel. And I would, that's pretty much all you should need. And your little IRACs, if you do some IRACs, it should be clear to you from those contract terms the two main things I am looking for, because as I said, there is those two IRACs that you will need to do. So there will be, and it's so snooty and papa again, so you're familiar with the characters, and as per usual, you're more than likely to have to advise one party and then advise the other.
That's what my notes say.
So, and I do this for a reason though. It's not just to be inordinately painful. It's, as I was saying to you before, part of the skill of being a really good lawyer is to be able to turn things around in your mind and try and see the best point of view for your client and the best point of view from the other party. And so you can't just get your blinkers on and go, oh, we're going to argue this and this and this, and then get into court and get completely shot down by the other side. Part of it is learning to divorce yourself from the argy-bargy of what's going on and turn it around and kind of flip it on its head and back together again, and, you know, be prepared for every contingency. One of the best little anecdotes I've heard on that point was by my wonderful copyright lecturer in London. And he studied at the feet of one of the very best IP barristers in London. And he said, he was a junior, and he said the barrister got out and just gave this cracking set of submissions. And then he said, it was a career decision. Do I pass the note or do I not pass the note? And he said, I passed the note. And on the note, he said to his senior, you just argued for the other side. And he said, without even skipping a beat, this barrister got straight back up there and said, Your Honour, I'm sorry to have misled the court in thinking that I'd concluded my submissions in this matter, but I just wanted to put out for your Honour's consideration what the best possible arguments would be that my learned friend could make. And now, Your Honour, I am going to show you why Your Honour should find in favour of my client. And he went down the list of submissions he had just made, and he shot down every one of them. And that, peeps, is where I want you guys to be in terms of your legal analysis. That's the level that you need to aspire to. I think it's a wonderful story of bravery and courage and intellectual grunt. You know, you're not afraid to get out there and go, phew, yeah, okay, woohoo, we can still save this, you know. So
I guess it's looking at where the other side's going to come from and be prepared.
Exactly, and that's why I draft my assessments the way that I draft them. Because otherwise I found, you know what, with first years you say advise Sally, and then all of a sudden you get 70 assignments that are so fixated on getting Sally some kind of answer that they tend to either downplay stuff that's going against them or ignore it.
Or do what I did in contracts A and just think that my client's innocent every time.
Yes. Yes, exactly. And so you got to get a bit of that jaded sense of really, you know. So that's it. That's contract B. Yay. I hope you had fun, and if not, I hope you didn't fall asleep too many times. Anyway, we've got our Zoom next week. That will be solely really on exam prep, but as I said, you know, I'm hoping that you guys have already started at least some of that. And I won't be answering any more of those marvellous email questions that I was getting at the beginning of the week. I'll answer everything next week, but apart from that, unless you got any queries, it's dinner time.
Thank you so much, AJ.
No
it's
worries.
been a great term.
No worries. My pleasure. And get all your mates to do a have you saved for me, because I'm running at about 25%, so I really want to boost that number.
No worries.
Okay. Thanks, guys. I'll stop.
Bye.
Bye.
Michael, that shirt sucks.
Have a terrible weekend, Tam.